what we have on this screen is just that in the native title and cultural heritage space, there's actually different layers of stakeholders, and it's really important to understand how to identify the right stakeholder and at what the roles and responsibilities of each of the different stakeholders. So as we went through quickly before the break, the Native Title Tribunal is actually a great place to start if you have no idea where to look or who you need to talk to. So on the Native Title Tribunal, you can get some maps, which this is one of them that's on the screen, and they can show you a map of all of the native title claims that are in Queensland or whatever state you're in. It can show you where all of the Indigenous land use agreements are. It can show you where all of the PBCs are. And it can also show you where all of the rep bodies are across, or when I say rep bodies, I mean Aboriginal, Torres Strait Islander representative bodies. We call them rep bodies for short. And I did learn that as planners, you guys also talk in like acronyms, and which is what we do in the native title cultural heritage space. Everything we talk about is in acronyms. You could have a whole sentence just using acronyms, and everyone would go, "Yeah, cool, we know exactly what you're talking about."
We don't acronyms at all. We're very, very plain English.
Oh, I see. Now, one of the important things to understand is that there is actually a relationship between the Aboriginal Cultural Heritage Act and Torres Strait Islander Cultural Heritage Act and the Native Title Act in how they talk to each other in relation to how you identify who the Aboriginal party or Torres Strait Islander party is for an area. So what the Cultural Heritage Acts have done, instead of coming up with their own way of or trying to create a new system of how you would identify who you need to speak to, is that it basically incorporated the provisions of the Native Title Act. So there's a hierarchy. So if you are a prescribed body corporate, so if you have native title determination, you are the Aboriginal Cultural Heritage Party or the Torres Strait Islander Cultural Heritage Party. If you have a registered native title claim, you are the Cultural Heritage Party. If you had a claim and your claim, for whatever reason, has been dismissed, the people or the applicants whose names are on the register of claims are the Aboriginal or Torres Strait Islander Party. And then the last group is you may then have where there is no determination, no claim, or never has been a claim, is that you then may have, it would be the group of Aboriginal or Torres Strait Islander people who, because of their laws and customs or historical responsibility for the area. So that's why it's important to understand how to identify your right stakeholder, because there is crossover and they have different functions and responsibilities under the different acts. Is that clear? So this is where Josh is talking about, because normally I would say clear as mud, knowing that native title and cultural heritage is not clear as mud at all. And I use that in the Torres Strait, which I have worked for a number of years. And I said it in a meeting in one of the Western Island communities. And I was one of the only females in a meeting full of men. And said clear as mud, explaining something, and everybody went silent. And then they wouldn't look at me in the eye, and they all kind of, looked in different directions. And the PBC chair had to write on a piece of paper to me, because I was like, well, I'm trying to explain it even further, because I thought I wasn't explaining it clearly because they hadn't understood it, because no one was giving me, yep. Normally they would say, yep, keep going, Cassie. No one would look at me. No one would say everything. Everyone was looking at the ceiling. And the PBC chair wrote on a piece of paper for me and said, in our language, it actually means female private part. So I've just said clear as mud, and that's not actually what it means. And no one had ever said to me, don't use the word mud in that context, because I use that all the time when I'm trying to explain something. Clear as mud. Is everyone okay? So that was my lesson. So now I don't say clear as mud at all. I just say, is that clear? Everyone okay? It was very embarrassing. I went quite red and then had to try and somehow collect myself and continue the information session, knowing that all of the men have completely embarrassed by what I have just said. So we all make mistakes, but it's, I suppose just being aware of those things when you're engaging.
Practical tip number one.
Yes, practical tip number one.
Cassie, before you keep going on with that next bit, what was the last part you described? So after the unsuccessful claimants, then they become the Aboriginal and Torres Strait Islander Party. What was the last bit?
So it's the last group that it is they're normally a group of Aboriginal people who have some historical responsibility for the area, or under their laws and customs have responsibility. So I think it's section 35(5), and it's a two-prong. So if they have their laws and customs, they are responsible for that area or cultural heritage under that, or because of their historical affiliation with the area, they then have responsibility that way as well.
Okay, good, thanks. And they don't have a, like you gave a terminology for the other ones, the Cultural Heritage Party or the ATSI Party, but is there not a term for this?
They would be the Aboriginal Party still.
Okay.
They're just, that group is one of the hardest to identify, and that's where you would need to engage with. So if you did all of your searches, so if you went to the Native Title Tribunal's website and you looked in the area where your project you're working in, and there's no determination, there's no registered claim, there's no historical claim, so there's nothing there, what you would do is you would then contact the Cultural Heritage Unit within DATSIP, and you would ask them, because they have regional offices, and part of the role of the regional officers is to make relationships and help identify who those contact people are on the ground.
And would the response to that question to DATSIP generally be recognised by Aboriginal people of a particular area, or Torres Strait Islander people of a particular area? Is that a contentious, determination, for want of a better word?
It kind of depends on the history of the area. So for areas where there isn't or never has been a claim yet, there is a general group of people that have been involved in cultural heritage negotiations. So they have a history, and they're normally generally recognised. You occasionally maybe get one or two small disputes between a couple of families about who it is, but most of the time that's it. The regional officers have a pretty good lay of the land as to what some of those relationships look like, and can give you some tips on how to navigate that as well.
Okay, and would that also be an acceptable way of finding the broader parties that would be involved in the Human Rights Act consideration?
Yeah. I was going to say, the other thing is the cultural heritage. Under the Cultural Heritage, I think I talk about it a little bit later, but under the Cultural Heritage Act, there is, in relation to identifying who your stakeholders are, there are what are called cultural heritage bodies, so either a Torres Strait Islander cultural heritage body or an Aboriginal cultural heritage body, and one of their primary functions is to actually help people identify who they need to talk to. And there is, I think we have it as a handout, but you can get that off DATSIP's website. If you go to DATSIP's website and you go to the cultural heritage section, you can actually get a list of, shows you where they are.
Yeah.
And you can just click on them, and they'll show you, then you get the contact details of the cultural heritage body, and then they should be able to help you identify who you need to talk to.
Okay, thanks.
I think Pia may have sent it out. If not, it'll come after this session. But there's a number of handouts. Like there's a copy of the duty of care. There's also the map that shows the different ONTBCs.
Yep.
I think they're ONTBCs.
No, so that map is the rep bodies.
The rep bodies, sorry, which is the land councils in some. And then there's a separate table that has all of their contact details for Queensland in there. So we've already done that for you guys. Okay.
Okay, so this is which Josh touched on a bit earlier, is that under the Cultural Heritage Acts, there is a statutory duty of care that all land users have. So, and that is the duty to take all reasonable and practical measures to make sure that the activity or what you are doing will to either minimise any harm or avoid harm where practicable. Now, what the Act does is it also sets out in Section 23 a whole heap of steps of which the Act and the Queensland Government have said these are things that we would consider reasonable and practical steps. And they would be things like identifying your Aboriginal party, Torres Strait Islander party, engaging with them, developing an agreement, getting them to go out and participate in a survey, doing a search of that SIPS register or database, and understanding the landscape of the area of which you're working in. So now the duty of care is it comes with a penalty. So in the event that you are found to have breached your duty of care, you can actually be fined. So you actually get criminally prosecuted and can be found guilty and be fined if you are a company or a corporation up to $1.1 million, almost $1.2 million. And if you are an individual, it's $117,800. So it's actually quite a substantial fine. There hasn't been that many prosecutions, and if you get prosecuted in the magistrates court, and it's the state government that actually prosecutes you on behalf of the Aboriginal Torres Strait Islander party for that damage. There is also the ability of the magistrate to actually refer you to 2 years imprisonment for breaching your duty of care under the Cultural Heritage Act. So it's actually pretty significant, and it's really important for land users to understand those obligations because there are some pretty serious penalties that sit behind that duty, which is why it becomes important to identify, who you need to talk to and get them involved as early as possible.
Yeah, and you'll see in the attachment that we've given you the duty of care guidelines, and it actually gives you different categories of disturbed areas and things. So quite clearly identifies, what they are, what the category is, what the level of damage might be. There's a whole heap of things in there. So, and we'd be happy to take questions, after. If you want to email us separately, that's fine.
The duty of care guidelines were gazetted to help land users understand their responsibilities, and that's also part of that process that I explained about, setting out a process of which that you can set out a process where land users can still go ahead and use their land and do what they need to do, but also finding a way that protects cultural heritage where possible. So you can satisfy your duty of care by looking through the duty of care guidelines and going, yes, my activity fits in the category, a particular category, and then that category in the guidelines tells you what steps you might need to do in relation to your engagement with the Aboriginal or Torres Strait Islander party. Then the other way you can satisfy your duty of care is under a CHMP, which we briefly touched on when we were talking about ILUAs. So, like I said, under Part 7, if you have an EIS, you have to do a mandatory CHMP. There is also an option to do a voluntary CHMP. So if your project doesn't require an EIS, there's nothing to stop you from doing a cultural heritage management plan. And the benefit of a cultural heritage management plan is that you have to lodge it with the cultural heritage unit within DATSIP to have it approved by the minister. So it actually gets approved by the minister, and the minister they have a record of where CHMPs have been registered. The other benefit of a CHMP is if you have a potentially difficult group, what happens is the CHMP, there's also CHMP guidelines available on DATSIP's website that set out that once you have to notify, people then respond, you then start your negotiation, you then have about 3 to 4 months to negotiate a CHMP. If you're with a really difficult group and you can't get the negotiation outcome, that there is an option that you can then seek mediation assistance from the Land Court for them to come in and assist you in your negotiation to help get an outcome. If that is still unsuccessful, you can actually make an application to the Land Court for them to approve your CHMP without endorsement from the party. That then, once approved, would allow you to do the activities, provided you were following the process set out in that agreement. Obviously not a great way to kick off a relationship with the Aboriginal party in your area, but it does provide a process of which you can engage and hopefully then work to repair the relationship whilst doing your activities. Now, the other way you can do it is under what's called another agreement. So this is actually the most common way in Queensland that we deal with this, and that we do them under another agreement. So they might be called a cultural heritage management agreement, an inspection agreement, or terms of reference. They all have different names depending on which lawyers drafted it, but basically it means the same thing, and it just sets out how the parties are going to work together in order to make sure that cultural heritage is protected whilst project activities are being done. So that may include a survey, it may include test pitting, it then normally includes management recommendations. So that's normally all set out in your agreement. So how do you comply with it? So, best practices, you identify who you need to talk to, and then, building that relationship with them. So, or in the event that where you don't know, it's not easy to identify, reaching out to the various different stakeholders. So whether that's the rep body for the area, the tribunal sometimes is able to assist, the Native Title Tribunal that is, the Cultural Heritage Unit, or other parties who might be in this space. So reaching out. So for example, I do some work with Powerlink, and we've got a project we need to connect into the system down in southern Western Queensland. Haven't done any work down there before. There's no registered claim, never has been. So I'm in the Section 35 group of people, need to identify who has responsibility. But I know 2 other proponents have been down there and have identified and negotiated. So I've reached out to both of them and asked who came forward, because they actually notified, and people stuck their hand up to say, yes, we have responsibility for this area. So that's another way. Relationships and connecting with your network is also a way to help identify who you need to talk to as well.
Just got a question from Julie. Is a CHMP triggered by an EIA in any other legislation, or only in a specific piece of legislation?
So I'm not too. There is a requirement under the Aboriginal. So one of the issues we have with the management and protection of cultural heritage is that the Aboriginal cultural heritage is a standalone piece of legislation. So, and this is something, because it's currently under review, but one of the feedback has been there needs to be a way in which the other legislations in relation to approvals and land use are connected or refer across to the Cultural Heritage Act, because at the moment there is no cross referral. So it would only be once you've lodged your EIS that if you hadn't attached or outlined how you were going to deal with Aboriginal cultural heritage, you were then, pointed in the direction of that you need to actually address cultural heritage. But at the moment, the Aboriginal and Torres Strait Islander Cultural Heritage Acts don't talk to other pieces of legislation. They are drafted as standalone pieces of legislation, which causes difficulties, because you have land users and people who are wanting to do projects who may not actually know that the Act exists or the processes that they need to follow until quite a substantial amount of time down their project pathway. And then when they're told they have to come back and address cultural heritage and native title, it then puts a lot of strain on the relationship and negotiations, because then we're normally, pretty much all of the time, we are given a specific time frame of which we have to reach an agreement to comply with the proponent's project time frame they need in order to get their financial approvals. But that's not our fault. It's not our problem that your advisors didn't advise you of this process, but then they play hard with us in relation to meeting and negotiating in accordance with their timeframes. And that causes massive issues with the relationship. It also leads to what Josh was talking about, consultation fatigue, because you'll have proponents who want to meet every second weekend just to get it done in order to get the outcome that they need, and it's just not practical. Which is why training sessions like this and making everyone as possible aware of the Cultural Heritage Act and the Native Title Act and how they work, so that people are more aware of it. And it is something that pretty much every practitioner in Southeast Queensland in this space, we always are asking the Cultural Heritage Unit within DATSIP to provide more training, provide more information that shows people who are doing these types of projects that they have to be aware of these issues. I hope that answers your question, Julie.
So, Cassie, in terms of other legislation, obviously having a native title claim obviously makes then, Future Act notices being issued for any development, which then would lead to a cultural heritage management plan in some instances as well, is probably the easiest way to help people. But when there isn't a group or a claim, obviously that makes this process a little bit more difficult.
Oh no, I think it's still difficult. We have Commonwealth and state government departments whose governments are responsible and who have drafted these pieces of legislation, who still don't know that they exist. So it's always eye-opening when people go, "We didn't know this was here." I'm like, it's been here for 17 years, so I would think someone in your organisation would have a bit of an understanding about it. It's not you. We just didn't make it up. But you will have, Queensland government is notorious for it, doing projects, and no one within their project team actually understands or even knows that this act actually exists. So did that answer your question, Julie?
It partly did, but when you're referencing EIS, do you mean EIS under the Cultural Heritage Act, the Aboriginal Cultural Heritage Act, or do you mean an EIS under another piece of legislation?
So it'll be an environmental impact statement that will be required normally under the what is the State Development and Public Works Organisation Act, or other. There is another act. I just can't think of it off the top of my head.
So if there are other acts or regulations that require an environmental impact statement or assessment of some sort, can we assume that they also will trigger that?
Yep, I would. It would be your safest best.
Yeah, good. Thanks.
So what this slide is talking about is that there is a cultural heritage database. So this is one of the sections of the Cultural Heritage Act. So this is actually a place where Aboriginal parties, if they wish to, they don't have to, it's not compulsory, they may choose when they find artefacts or when they, they want to record and protect their areas or places that are significant to them, they can register it on the database. So it then is information that is only accessible to them. So they've got to get their own login, and then they basically, can manage their sites and the records that they have of them on the database. So they don't actually need to tell the Cultural Heritage Unit within their application as to what the story is that sits behind it. They can just say that there is something there. It might be an artifact, it might be a story place, it could be a ceremony place, and then they can also ask to put a buffer zone around it. So they might say, we want a buffer zone of 10 kilometres, or 100 metres, depending on the significance of the area. And it can also be linear. You could have a dreaming track that is linear, so it depends on what it is that they are seeking to have registered that they put up there.